Morning, everyone. Okay, so first of all, does anybody have any questions of specific issues that they're wanting to discuss, so I can just make a note of it? Edna?
Something that happened recently to me, part of this is confession, part of it is how much trouble am I in? I'm working a transaction right now where it's new construction. The builder told me that he has a real estate license and he has chosen to work directly with me and my clients because we're trying to get this closed in a really short time frame.
Okay.
And so we've sort of left the listing realtor out of the picture.
Oh.
Sort of.
Okay.
By his choice and hers.
By the listing realtor's choice.
She's been aware and she's been made aware.
Mm-hmm.
So what kind of trouble?
Yeah, you're not.
What kind of trouble can I be in?
You're not. Actually, I've sat at the state level on a professional standards ethics hearing panel on the issue that deals with exactly the standard of practice that governs that, which is that under the Code of Ethics, I think it's under Article 16, I think, but it's that all dealings shall be made through the agent representing that client unless that agent consents to something different. So you're not in violation as long as you haven't been sneaking around behind that person's back, and it's a little, you have to do a little more than that. You have to at least get their consent to be dealing with a builder. Now, builders are probably the most common case where we see it happen.
And he said he's a builder and a licensed realtor and he had it placed with this agent just.
But be that as it may, if the agent was kept in the loop and one way or another confirmed that it was okay for you to have direct dealings with that agent's client, then you're fine.
Okay. I have an email for that.
You do? Okay, so in an imperfect world, you would have never gotten explicit consent, but it would have been pretty clear implicitly that the other agent knew and was okay with your having direct dealings with their client. And if they were implicitly okay with it, even if we don't have something we can point to that says very explicitly, yes, that is totally fine, have at it. They're not likely, if you don't think you're running afoul of that agent's territory, they're not likely to file a complaint, and so it's going to be a moot point. But if they did, the key issue is, did they somehow consent for you to do that?
So it would be the agent who would make a complaint?
Correct.
Okay.
Now, consumers or agents could make a complaint, but in that situation, typically the complainant is going to be the agent who had the other party, leaving them out of the loop, running around them behind their back.
Don't expect any problems since it was a full price offer closing before the end of the year.
But be that as it
I'll
may.
wait to show off
All right, and it's dismissed.
Thank you for making me feel better.
Yeah, but that's that. The builder scenario, Russ has dealt with that, Brad's dealt with it, a lot of us have dealt with it at some time or another, because especially if you're dealing with a prolific builder who does this musical chairs rotation of who gets a listing. You brought them a buyer, you're going to get a listing. And it's not like they have an exclusive arrangement with one particular agent, and so it's somebody, if it's a really prolific builder, it's somebody we're all going to know. We know at some point in the transaction, especially if it's new construction, and almost guaranteed if it's not 100% finished, at some point the buyer's agent and the buyer is going to have direct contact with the builder. Guaranteed the buyers are, whether it's finished or not, because there's going to be a final walkthrough with the builder customer service person. So that's the situation where it happens the most frequently, and it makes it the easiest for agents to think, well, I know the builder, it's not like I'm not letting the listing agent get paid for having the listing, but still as a matter of protocol, you always want to be very, very deferential, because you never know when doing it. When you think there's been implicit consent but not explicit consent, you never know when that agent's going to get miffed later in the process and decide they want to zing you on that particular item. Okay, so let me talk earnest money for just a minute. I'm looking at my list of what I told you I was going to talk about. So an earnest money question that got kicked over to me this week was, it was a combination of factors. We have now had in a market where more transactions fall through, because everything's more complicated and more transactions fall through. We're increasingly dealing with situations where a buyer who has a deal fall apart, let's say after a home inspection, and there's no question that the parties aren't coming to an agreement. So in the agent's minds, probably on both sides, in the agent's minds, there's no question this is not going to close and nobody's going to sue anybody over it. We know it fizzled under the home inspection contingency and it's just a dead deal, but we don't have a fully executed earnest money release form. And so then what can happen is the buyer, especially if they're under some sort of time constraint, immediately has to get under contract to find something else. And so one of the questions is, can I recycle their earnest money? But you have to remember that until our office has final written confirmation on the disposition of that earnest money signed by all of the parties to the contract for which that earnest money was originally tendered, that until such time as that happens, that earnest money remains attached to that dead deal and therefore cannot be repurposed and attached to another deal at the same time. So that'd be a real easy thing to miss because you know it's dead, the other agent knows it's dead, you're not expecting it to be contentious, you don't expect somebody's going to resurrect it later and sue for specific performance and find out the earnest money's gone missing. But until our office has one of the only 3 ways to do this, that earnest money has to stay here and stays attached to that same deal. Yeah?
Who originates the release form? Which attorney?
My recommendation would be seller's attorney. I mean, it doesn't matter. So the short answer is it doesn't matter, but the more common scenario is seller, we all know, has to have an attorney in a deal, and hopefully will have had one as soon as you get the ink dried on the contract. Hopefully you got a seller's attorney lined up so that you can at least get title work going. And so it's probably a little more common that the sellers would already have retained an attorney, and the buyers are a little more likely, at least in my experience, to wait a little later in the process. But it doesn't matter which party does it, but going back to something we've discussed here before, we cannot have an in-house form or a form that you're using in your own personal stash as an earnest money release. Let that be something generated by the attorneys in the transaction. Russ?
I just had this in Monticello where we had a house sold, everything was moving through fine, found out the house is in the floodplain. They changed the map and no one knew it. For $800 a year, they could still buy the house. They didn't want it. The seller said, well, that's not our problem. We didn't know it was in the floodplain, you didn't know it was in the floodplain, you can get insurance, we're not giving the earnest money back. So we fought over that for months and finally they split the earnest money, but it's just a real life story. It's a pain in the neck. And I kept having the other agency call me, Coldwell Banker, which we do a lot with, and they do a good job. They kept dinging me, can't you release the money? I said, you know I'm not gonna release the money that the attorneys did.
Right.
Finally,
Right.
the attorneys worked it out, you know, they're fussing that they wouldn't return each other's calls, but after months, they just split it and we're done.
I had earnest money sit in our trust account for years and years and years on a really, really, really low dollar transaction that had gone south. So be sure an attorney's doing it. You'll recall that part of the reason that we sort of made that announcement that we need to make sure you have an attorney generate the release. And I don't expect the attorney's going to charge much, if anything, for it because they just have a release that they're going to pull out of their own office's files. But we need to not do that for a couple of reasons. Though the contours of each deal in terms of the termination and mutual release could vary from transaction to transaction, so you want to make sure an attorney's eyeballing it. But secondly, during the salesperson to broker transition course, using an in-house within a brokerage form was a poster example of something that constituted the illegal, the unauthorized practice of law. Again, I had one other earnest money question to address. We had on the subject of earnest money a transaction where the buyer's agent had put one amount in the contract when they tendered the offer, and then because of a discrepancy between what the agent put when they put the offer together and what they had said to the buyer had tendered a $1,500 earnest money check when the contract referenced $1,000. And then the question that came to me was, so as a company, do we need authorization to release the overage? And my answer to that question was no. I mean, obviously, as I discussed earlier, we have to keep the amount of earnest money that the contract indicates has been tendered as part of that transaction on file until its disposition has been ordered by the court or agreed upon by all the parties to the transaction. But if the amount had an overage in it, over and above what was indicated in the contract, there's no problem with the office just going ahead and cutting a check for the difference. Walt?
If a seller does not sign to release earnest money, what's the maximum amount of time that money has to stay?
I don't remember years. I mean, it eventually
Hasn't that been
gets
shortened recently? Hasn't that been?
That's
I think
what
so. It
they-
gets swept.
It's gone
It
to
was
6
5, I
months.
think.
Yeah, so it gets swept into, okay, so 6 months now. It used to be years, and now it'll get swept into the state. It goes to
Yeah.
IDFPR.
Mhm. Well, actually, it goes to the Treasury.
Under a relatively new
Yeah.
provision from
Under
IDFPR.
the state law, like bank accounts that aren't used forever, I mean, if it's unclaimed, sort of unclaimed money, it goes to the state?
It goes to the state and it can they can decide what to do with it.
But I thought, I'll have to look this up, but I'm thinking that it stays under, I'm thinking I'm thinking the license law, the Real Estate License Act dictates what that can be used for. I don't think it just gets swept into a general fund.
So it's like, our office doesn't have to keep track of it for years and years and years?
No, apparently not anymore.
Okay.
So anything else on earnest money? Don't forget, this may go without saying, but this is happening all the time. Don't forget that our contract has two different blanks for earnest money and the opportunity for earnest money either to be paid in multiple installments, or if you have a client who forgot to bring their checkbook at that moment or is scanning and emailing you an offer from California and they need to overnight or put in snail mail an earnest money check, don't forget to fill out the contract to indicate that $0 have been tendered at the time of the offer, and that the X number of earnest money dollars are going to be tendered on or before, and then be sure you put a realistic deadline. And then it's a good courtesy to follow up with the other agent and make sure that you send them a copy of the check when it does eventually arrive. And on the subject of unauthorized practice of law, one of my teasers was that, I have actually said in our contract committee meetings, one of the things I lament is we hear about the unauthorized practice of law and admonitions about it when we're getting our licensing coursework done. We hear about it in CE courses, and I talk about it here all the time. But there's really no substitute for watching somebody's rear end just get totally nailed to the wall for doing it. Because I've never seen anybody get nailed for unauthorized practice of law, and I don't know if any of the rest of you in the room have either. But the ARDC, which is the Attorney Registration and Disciplinary Council, which is, I believe, under the auspices of the Illinois Supreme Court. So I believe it's part of the judicial branch of the state government, and they're the agency that's in charge of attorney discipline and licensing. The ARDC now has been given authority to, on its own, prosecute instances of the unauthorized practice of law. So the ARDC now has the authority to file a complaint in circuit court against anyone who's committing the unauthorized practice of law. So, it may mean that we won't see anyone immediately nailed to the wall, but it does mean that there's this whole new vehicle for prosecuting cases like that. So I think one of the dangers in our line of work, especially since our agents tend to be more experienced than most others, is that certain things you may do so routinely that you don't even think in terms of, is this crossing a line? Because if you've done it a million times and 12 of those times an attorney looked at it and it was fine, and so on the next deal where the buyer didn't have an attorney yet, you went ahead and made some handwritten change to the contract. It's really easy to get in the habit of doing, but just be aware that the landscape is changing, and the mechanism and I think the probability of getting zinged for unauthorized practice of law is now higher than it has been. One of the things that I have here that's always interesting to look at is a quick summary of some of the legal issues that are in the news that affect Illinois folks. So here's a quick summary of some discipline cases. A real estate broker license was placed and refused to renew status due to failure to deposit a $5,000 earnest money payment into escrow, failure to return earnest money upon cancellation of a contract, and failure to submit escrow records to the department within, this is IDFPR, within 24 hours pursuant to a department request. So licensee did not get their license renewed and had $5,000 dinged. A real estate salesperson license, and this is one that I put in my teaser. This is the $25,000 fine. A real estate salesperson license was revoked and fined $25,000 for engaging in dishonorable, unethical, and unprofessional conduct.
Is it in this MLS?
No. After found to have misled a client by failing to disclose, and I'm going to let you fill in the blank. What are some of the most common things that we think of?
Agency.
That's what you would think, but you were wrong.
Oh gosh.
This is why the teaser. For failing to disclose a compensation agreement with another party to the transaction. $25,000 and a license revocation.
Because they were getting paid out from both sides.
Apparently.
Yeah.
So we all think dual agency disclosure, and that being the most common way to get zinged and to sort of treat that as a capital offense under the license law. I found that pretty interesting because, as I said in my teaser, that's not as evil as you would think it would take to get fined $25,000 and be revoked, not just non-renewed.
Do we know where that happened in the
No.
state?
An unlicensed person, not in this newsletter, I could probably look it up. IDFPR has a digest of those. An unlicensed person was ordered to cease and desist the unlicensed practice of real estate and assessed a $6,000 penalty. So anyone who has unlicensed assistance, $6,000 is probably more than that person makes in a month or maybe 2 months. RESPA. We have discussed RESPA here before, and I've discussed the issue of whether a processing fee or a transaction fee or an administrative fee is a violation of RESPA. And there have been differing interpretations of that, and HUD has been responsible for enforcement of RESPA. So there's a few different mechanisms where RESPA can be enforced. You can be criminally prosecuted, HUD can enforce it administratively, or you can be civilly sued for an alleged violation of RESPA. So there's a few different enforcement mechanisms. But the thing that is totally new, that's this big monstrous bureaucracy that's actually been in the news this week because the new commissioner of this, the CFPB, the Consumer Financial Protection Bureau, I believe it is. And so that's getting a whole new bureaucracy in place, whole new commissioner set up, and they now are going to be authorized to enforce RESPA. So we're only just now starting to figure out how HUD has been interpreting parts of RESPA, and now there's going to be a whole new federal bureaucracy that is empowered to enforce it. So I'm going to read the last part of this. This is a case, a couple of the documents that I have here summarize a case that went from federal district court into a federal appellate court. And on this particular issue, differing jurisdictions have come to different conclusions, and so there's not a clear-cut answer. There's binding precedent in certain specific parts of the country with respect to that jurisdiction's appellate court, but it's not uniform nationwide, and now even that is going to be subject to change. Real estate brokers continue to charge additional fees to cover the cost of their services. Well, that's not new. I mean, all of us are looking for ways to try to make up for the decline in revenue. These fees, often mistakenly referred to as administrative/professional fees, are more appropriately identified as additional flat fee commission charges. It's been 2 years since a federal district court in Busby versus Realty South called into question whether real estate brokers and agents must perform separate and distinct services under Section 8B of the Real Estate Settlement Procedures Act in return for charges assessed by real estate brokerage companies. Since then, many real estate brokers have restructured their compensation structures to make flat brokerage fees part of overall real estate commissions, which is an approach the U.S. Department of Housing and Urban Development gave credence to in a January 2010 letter. So HUD had issued an advisory letter that suggested that that was the way to fix it. So we've discussed this before, but in a nutshell, if you wanted to be certain that you were in compliance the way HUD was interpreting it, rather than saying that your commission was going to be X% plus an X number of dollar transaction fee or administrative fee or marketing fee, it really needs to be that the total commission due under this agreement shall be, and if you're going to do the combination of flat fee and percentage, X% plus X number of dollars. The key is not to make it sound to the consumer like that flat fee segment of the brokerage fee is for anything separate and distinct. Because if you give the impression that it's for something separate and distinct, then you run the risk of having to prove in court, which means if you get that far, you've already lost. Having to prove in court that you had something separate and distinct from the other marketing that you were doing for which you were assessing that fee.
So you just say 6% plus $50.
Yep, or $500. So
Right.
so the amount is not at issue.
But you don't say any kind of anything. It's
Correct, just don't
$50.
call it anything other than lump it in as part of the brokerage fee or lump it in as part of the commission. The other related item is, when it goes onto the HUD settlement statement, make sure that there is a single line item for the total brokerage fee. Do not allow the brokerage fee to be the percentage on one line and then a transaction or administrative or processing or marketing fee on a separate line, because that becomes a problem as well.
So how do you do that?
How do you do what?
I'm just wanting to verbalize it here, that you had, whoever sets your closing
Oh,
is to tell the attorney's secretary, this is a flat fee.
And ask for a copy of the HUD, or look at the HUD when you get to the closing table. If you're party to a transaction, one of these that got litigated was actually a buyer side transaction where the buyer's agent, who was already getting paid cooperating compensation via the MLS, still had a policy of charging a flat $300, I think was the fee amount, paid by the buyer. But that still got, that person was still found to be violating RESPA because it was really not separate and distinct. It was the same, even though the money was coming from the buyer and was on top of what they were getting paid as a co-broke, it was for doing the same services that the co-broke was paying them to do. Well,
So administratively, here in the office, when we fill out the folder for a sale pending, let's say on the listing side,
Mhm.
we would put 3% plus $195 or whatever.
Mhm, yep.
And then you'll remove that transaction fee line or whatever, it'll just be lumped on one.
Just need to say flat.
Correct. I mean, obviously, the office needs to know how the math works. So you're gonna have to put the percentage, if you're doing a percentage plus flat fee combination, the office staff needs to know how to do the math so that they get commission checks prepared correctly. So the math is the issue, it's that you can't label the flat fee part of it, the fixed dollar amount part of it. Just don't make any effort to call that anything other than commission or brokerage fee. So make sure the brokerage fee is just defined as, if you're choosing to do both methods, X% plus X number of dollars. Okay?
All the way through, from the listing contract.
Right,
All the way through.
right, because in the listing contract, we don't want to be in violation of RESPA because of the way it's in the listing. We don't want to just be trying to do a workaround at the closing, make sure that the listing agreement doesn't say that either. So one interpretation is, so the Busby Court considered Section 8B of RESPA, they determined that RESPA prohibits a single settlement service provider from charging fees for which no services are performed. As HUD first expressed in this position in a 2001 policy statement, the court gave deference to HUD's interpretation of Section 8B and held that a real estate broker must perform services separate and apart from the real estate services performed to earn a real estate commission in order to justify a flat real estate brokerage fee. However, since then, the Fifth Circuit Court of Appeals has expressly considered whether Section 8B of RESPA applies to undivided, unearned fees. Because part of the issue was that subsection 1 interpretation is it didn't apply unless the fee was divided with somebody else. So it could have been unearned, but if it wasn't divided with some other provider, then it was, according to one interpretation, not subject to that section of RESPA. But then you've had other courts that have held differently, and you had HUD that then issued an advisory letter that was different. So this from rismedia.com, this has a detailed article, and I looked this up separately after sort of the digest from IAR's legal update referenced that. I wanted to get a little bit more detail. It starts with first the good, then the bad, and then the last part, which I'll read, is finally the ugly. While the Federal Circuit Court continues to take sides on the Section 8B debate, HUD no longer has say in enforcing RESPA. So the letter that real estate practitioners across the country may have been relying upon to confirm that they were in compliance with federal law no longer is meaningful because there's this whole new agency. Effective July 21st, 2011, CFPB, Consumer Financial Protection Bureau, became the federal agency responsible for regulating and enforcing RESPA. Since many officials from HUD's office of RESPA transferred to CFPB, it remains to be seen whether CFPB will interpret RESPA in the same way as HUD. While it is possible CFPB could break with the past and reconsider the types of charges that create RESPA concerns, we expect CFPB will continue to take HUD's position that an undivided, unearned fee violates Section 8B of RESPA. With an arsenal of enforcement weapons more dangerous than HUD, once RESPA enforcement becomes a priority, the new CFPB could prove to be a force to reckon with on Section 8B issues. So not unlike what I talked about with ARDC now, creating a new mechanism for unauthorized practice of law prosecutions, it's possible that there's going to be significantly more heavy artillery in the federal government bureaucracy aimed at enforcement of this. Real estate brokers should continue to carefully structure their fees to avoid RESPA scrutiny. Notably, a real estate broker should make clear as part of the listing or buyer's agreement that its real estate commission consists of both a certain percentage of the sales price plus a flat fee. This total amount should then be disclosed as a single dollar amount on line 700 of the HUD 1 settlement statement. And if that's something that you're going to start looking at, you might make a note since the form has 400 lines on it. In other words, the broker would be increasing its price for the services it performs to earn real estate commission, which should avoid the need to justify a separate flat fee under Section 8B of RESPA. However, if a broker continues to charge a separate flat fee in addition to its real estate commission, the broker must be prepared to demonstrate that it performs separate and distinct services in exchange for the fee under Section 8B. That is a lot of garbage for one small little issue, when the bottom line is even the federal government says, we're not trying to control your prices or your fee structure, and we don't begrudge you trying to fatten the profit margin when the market conditions are making the profits leaner. And even with that being the case, we have to make sure that we're wading through that minefield very carefully. One of the things I'll discuss briefly that is in contrast to our local market, we don't have a liquidated damages clause in our contract. You know, can somebody summarize what liquidated damages clause is? Okay, so the idea is, if you have a contract where, in the event of a default, it would be difficult or impossible to ascertain with absolute certainty what the actual damages were. Then liquidated damages provides a means by which the parties can agree in advance, in the event of default, a sum that's already specified in the contract is going to be the total extent of the damages. So as an example, there are some markets where the earnest money is attached to a liquidated damages clause. Our market does not do that, and so in our market, if somebody defaults, and in our market we commonly see really small earnest money checks. So if somebody defaults in our market, had a $500 earnest money check, and a transaction that was pending for months at a particular price falls apart because the buyer defaulted. Property takes several months to sell and eventually ends up selling for $10,000 less, and the seller can therefore prove $10,000 or more in damages. That seller can certainly sue the buyer for way more than the amount of the buyer's earnest money. So our market, in other words, is not one where you can just say, fine, I'll turn over my earnest money, I'll forfeit that and be done with it. It does not work that way. So liquidated damages are not intended to be a penalty, it's intended to just fix the amount up front, intended to reflect actual damages, not intended to be a penalty. So it's not intended to actually be an amount that's above damages, it's just an amount agreed upon when damage calculations are imperfect. There's a Trump Tower case in Chicago that came up. Buyer who failed to close on the purchase of a condominium at the Trump International Hotel and Tower sued the defendant for breach of contract and return of the earnest money deposit. The earnest money deposit was 15% of the condo price. The 15% was $328,269.60. And interestingly, after the default,
Bless you.
the seller was able to turn around and sell this condominium, which had been under contract at $2.188 million. Turned around and sold it for $2.5 million. So when it was all said and done, the seller hadn't actually ended up being damaged by it, and so the buyer says, well, hey, you don't get to keep my entire 15% because that's excessive, and the court ultimately on appeal determined, yes, they do. This is something though to be aware of when you're looking at contracts that are proprietary and not our MLS contract, because you may find a liquidated damages clause in a builder contract that a local attorney has prepared just for that builder, or it's possible to find it in a relocation company contract or in an REO type of contract. So I just wanted to alert you to the fact that our MLS contract does not operate that way, just so you're aware of the distinction. Don't start doing a legal seminar with a client if you're seeing a relocation company contract or some other proprietary contract that you're using instead of ours, but just be alert to that issue. And remember, whenever you're dealing with a contract that's something other than MLS, always get the attorneys involved really early. And also go ahead and mention when you're getting into relocation company contracts. The other thing to mention on the buyer side up front is a lot of these relocation companies will operate with some incestuous related title and insurance outfit. And in doing so, since we have some of the lowest title insurance costs in the country in our local market, in doing so you may end up being stuck with title charges that are considerably higher than what is locally customary. Now in some cases, if you have a blank that says other conditions, you could put in, I would still encourage you to consult an attorney because we don't want to get into a creative writing exercise, but I have put in the past on some of these and had an attorney review it, that buyer title charges shall not be in excess of that customarily charged in the Champaign County market. So that's one thing you can do, but the other thing to do is just set expectations. Warn the buyer up front. You're going to potentially get a very, very good deal on an institutionally owned property. Some of the best deals we've seen across the MLS in the last couple of months as off-season deals have been relocation company-owned properties. I just had a client sign a contract this week for one in Pasodum. Current owners, the transferee, bought it 2010 for $151,000. Great property, my buyer's getting it for $124,000. So there are some deals to be had. Warn the buyer, they may get stuck with a few $100s of title charges that would not be customary here, so they know that going in. Otherwise, you know what happens, they get an attorney, and the attorney then tells them at the closing table, you're being shafted. That's not a problem if you've warned them up front that be prepared, you're going to save several thousand here, you may be paying a few hundred extra with the title costs. So here's another interesting one. The headline here, buyer's loss of employment does not rise to the level of extreme and unreasonable circumstances that excuse the buyer from a contract due to the impossibility of being able to pay the purchase price. So I'll read this one, this isn't very long. Prospect Enterprises LLC versus Ruff. In this case, the buyer was relocating from Michigan to Peoria because the buyer had received an offer of employment with Caterpillar. The buyer and seller entered into a contract for the purchase of a townhome. Because the buyer still had a home in Michigan, the contract provided that the transaction be a lease purchase, which we're seeing a lot more of now. A lease purchase whereby the buyer could move into the townhome and pay rent and utilities beginning November 1st, 2008, and ending upon the first to occur of either July 31st, 2009, or the date upon which the buyer elects to close the purchase of the unit. In other words, you're going to either close by that date or sooner at the buyer's option. The buyer would then be responsible for paying the purchase price and closing on the sale. During the time while the buyer was leasing the property, he was laid off from Caterpillar and eventually given notice that he would not be rehired. The buyer vacated the townhome and moved back to Michigan. The seller sued the buyer for specific performance. The buyer raised several contractual defenses. One of these arguments was based on the doctrine of impossibility of performance. Under contract law, if the inability to perform the contract by one of the parties arises from, quote, unforeseeable events that result in extreme and unreasonable expense, end quote, or some other undue hardship that makes performance impossible, that party will be excused from performing under the contract. The court in this case, however, found the loss of employment is not unforeseeable and does not rise to the level of an extreme and unreasonable event that should excuse performance. It sounds a little less outrageous in this last couple of sentences. The court found the buyer knew he was an employee at will and had no promise of continued employment. Additionally, the buyer did not make his continued employment a condition in the contract with the seller. The court therefore determined that the defense of impossibility of performance does not apply to excuse the buyer from a contract merely for loss of employment. The court ordered that the buyer must pay the full purchase price and close on the property.
Wow.
Ouch.
Most states are at will states.
Right, now every once in a while you'll have somebody coming in. I mean, an example here would be physicians coming in with a contract. From the day they arrive, they know they have an employment contract, so as long as they don't do something that's a colossal screw up to get terminated for cause, they are guaranteed they'll have their job for at least the duration of that contract. But interestingly, the biggest short sale we'd ever seen in our local market was from a physician who came in, started building a $1.5 million or more dream house on their initial 2-year contract and did not, Windermere, and did not have it the contract renewed. So, thinking critically about that fact pattern, what would be the one way to have completely avoided that? Make it a lease with a purchase option. Don't make it a lease with a mandatory purchase baked into it. Now, the option isn't going to be as perfect to a seller because the seller won't have an absolute guarantee that that buyer is going to buy it no matter what. But remember, once the buyer is already there, and if the price being offered to that buyer is a fairly good price, and if you bake some other incentive into that contract, like a hefty security deposit that gets forfeited, or hefty security deposit, half of which gets forfeited if the buyer does not follow through with their option to purchase, then you'd still have some pretty powerful forces motivating the buyer to proceed. If the buyer had a job loss like this, the buyer won't be forced to pay the full purchase price and go through with it come hell or high water. And the seller would still be given a sizable chunk of money. If say, the security deposit was $5,000 and $3,500 of it, you want to make sure the tenant has some portion refunded or else they'll be incentivized to trash the property. They ditch the deal and trash it. So it would make sense to refund some portion of it. But that would be a way to structure this where there would still be an incentive under normal circumstances for the buyer to close. And if the buyer doesn't close, the seller will still end up getting some money on top of the amount of rent paid. But I thought that was really interesting because in this economy, of course, we all are sympathetic for, I've had deals fall apart because of a last minute job loss. Had 2 or 3 of those happen. And it's frustrating all the way around, but you can't really feel like the party that lost the job, the buyer that lost the job on the eve of closing, can really be blamed for it. Would have never occurred to me though that you literally could sue them for specific performance and prevail. So keep that in mind.
Except if they don't
How
have
they
an
gonna get
income
paid?
to meet their finances.
I'm guessing these people did. I'm guessing these people did.
That could throw a lot of cold water on a
I
lot
know.
of deals.
I know.
And that's not too many counties away in terms of precedent.
No,
Counselor.
it's more, to me, it's more interesting to see a Peoria deal referenced in one of these than to hear just another, than Trump Tower, for example. Trump Tower is interesting, like from a Monopoly board game standpoint, because it's like fake money because all the prices have so many more zeros on them.
It's interesting just to hear the numbers.
I know, right, exactly.
It's
But when
like,
you hear
wow.
Peoria, it's like, oh, well, that kind of hits close to home. Any other issues that you guys have going on these days? No, nothing.
You
Russ?
mentioned the rent option. I've got one in place now where the buyer found the person that needed a home and they were gonna be out of it, so it was gonna be a vacant house through the winter. So we worked with the attorney and have it in place.
The seller did or the buyer did?
The seller found the
Okay.
buyer himself. So I'm just sharing a story. So we contacted the attorney right away and worked it out where it is a attorney-prepared rent option agreement to try and take into consideration, we don't want to mess up potential financing when they can get it maybe
Right.
in 6 to 8 months, so.
We
I think
need
we're
to-
gonna have more of those.
I think we will too, and we need to be, as agents, we need to be really active participants in that process. Because remember, when it lands on the attorney's desk, the attorney doesn't usually have it anywhere near the depth of knowledge of the client's circumstances that we do. If we're the ones that have been working with the client, and we know exactly what their job transition situation is, what their income situation is, or in the case of one of my clients, exactly how many months it's going to be before their short sale from Arizona, which was totally an externality, not something irresponsible the client had done, because their market got cut in half value-wise right after they bought. We know all of those sorts of details about the client. The attorney who has it land on their desk does not. And so the attorney may either have a sort of a default setting of, this is how the last one of these played out, and so I'm going to model it after the last one. So it's important that we be really critical in evaluating those and helping to make recommendations to the attorney. Or if not making a specific recommendation, making sure that all the variables that we're spinning around in our heads are in the attorney's head as well, so that the attorney is equipped to represent the best interest of that client, and ultimately, hopefully get a win-win going. But in those rent deals, as Russ pointed out, right now, the most common thing that we hear sellers saying, they're crying uncle saying, I can't let it sit vacant and pay the utilities all the way through another winter. And so you've got sellers in some cases who are willing to do dumb and desperate things just to get somebody in there to pay utilities, when they'd be way better off making vacant house payments for 4 or 5 months than having a bad tenant in there that makes it impossible to show when we hit prime marketing season, because that could easily cost them more than the next 5 or 6 months of house payments.
And we've got Teresa, so we've got a combination. If we either get them in a rental agreement with Teresa, which I just did on one out there in Sawgrass, or the rent option, and make sure you've got to pin down what you're going to get paid when they buy it and have it there, because your listing may be out by then. The other thing that if they find their own buyer, then they think that they've done all the work, and this darn rent option thing has ended up being as much work or more, because we're not even close to closing. So I just kind of warn you, I think I kind of negotiated myself down too low on that deal. So I'm living with it, but I'm gonna be a little firmer next time, realizing that I'm a long ways from getting paid.
Some of the advice that I've given, so I've had 2 different prospective clients. One is a past client, so they know me well, I've done multiple transactions with them. The other is a prospective client that doesn't know me at all. And these both were from the last week. And both were pondering, do I rent, do I sell? And of course, one of the options when the thing's already vacant is we can certainly do both. If I list a property, especially if I've already gone and taken pictures, or you've already hired a virtual tour provider or whatever, you can certainly make that link available to Teresa, and she can use it for rental showings as well. But the advice that I have given the clients is doing both simultaneously. They're not mutually exclusive options. We can market them simultaneously, but we don't really want to see the opportunity, if we're going to go to the effort of listing it and treating it like every other listing, marketing it, spending our money on it, focusing on getting it sold. We really don't want to do that when we know that it's probably, all things being equal, 10 times more likely to rent than to sell at this time of year in this market, unless it's just really well priced. And if it were that well priced, it would have sold already and they wouldn't be focusing on renting. So the advice I've been giving people is, you can do both. I will do both, especially if I know it's one they're going to sell at some point in the future. I'll use the same photos, so I don't have to redo my marketing 100%. But I have strongly encouraged people with what we just discussed here, don't get a tenant in the door now unless you're prepared to do that and stick with that course for years. Years. Because if you do it if you're thinking in terms of, I can't let this sit through this winter, then as soon as you get a tenant in the door, you get most of the downsides of having rented the place out, whether the tenant's there for a week or whether the tenant's there for 5 years. When is the majority of the wear and tear being put on the paint? They're moving all of their earthly possessions in and out of the house, so a tenant that's there for 2 weeks is going to put probably 75% of the wear on that a tenant that's there for 6 months or a year is going to do. And once the tenants are there, we know that the lease calendar does not correspond with the prime showing calendar. The lease calendars typically are running July to July, but the prime months to have it showable are going to be March, April, and May. And so you've got all of these other problems that factor into it, and so we want to make sure, my approach with these prospective sellers and or would-be landlords is, I own several single-family rentals, many of our agents do, and so I'm able to tell them as a landlord, here's the good and here's the bad. If you choose to go down the road of being a landlord on this, do so knowing that it could be for multiple years. The market could make a very, very fast recovery, and you could get a tenant whose lease you agree to have end in April or May, so it can be vacated and put back on the market. But don't do that for a year and then have it vacated. Know that to put it back on the market, you're going to have the vacant house payment issue come up again for some period of time, except the next time you're going to have to recondition the house before you have it shown. Be very careful, and so the advice is get really serious about either renting it or selling it. We could do both marketing-wise at the same time, but try to get them to go in one direction or another. Because then you're going to equip Teresa to get, if renting really is the objective that makes sense for them, then getting them to focus on rent means they're going to make a difficult decision on pricing it so it will rent. And they can rent for a real bargain rent price, and it's still, even if it's not making them any money on a month-by-month basis, they're not only improving their cash flow by the amount of the rent relative to a huge deficit, but they're also improving their cash flow by the amount of the utilities as well. But also don't forget to point out to somebody who does not specifically want to become a landlord, where that wasn't their aspiration when they bought the house in question. Don't forget, in this economy, that means, Mr. and Mrs. Homeowner, somebody else's pink slip is your problem. Or, the other thing that I will point out that makes sense, because a lot of the properties that won't sell easily are the ones that are somewhat dated. They got middle-aged mechanicals on them. So the other thing I've warned people about, because I don't want to have to deal with it when it comes back on the market 3 years from now, is let's say you got a house that does not have a roof that's an issue today. The roof has 5, 6, 7 years left on it. So it's a middle-aged roof, nothing that's going to be an appraisal issue today, and they rent it for 3 years. Well, what have you just done 3 years from now? You've used 50% of the remaining life of the roof, and so then a house that probably could have sold without that being an issue or a marketing impediment today, suddenly that becomes a marketing impediment when it goes back on the market in 2 or 3 years. A roof that was just starting to show the very, very earliest signs of age now looks like a 4-alarm emergency, and they have to do a $5,000 or $6,000 or $7,000 roof job before the thing will sell then.
That's a good point.
What's the time period that if you convert your residence to a rental, that it becomes a investment property rather than when you sell?
To qualify for the capital gains tax exclusion, you have to have, at the time of the sale, the property has to have been occupied as the principal residence of the seller for 2 out of the 5 years preceding the sale. So in a typical scenario, it would be seller moves out, relocates, puts tenants in, and could have tenants there for up to 3 years thereafter and still qualify for the capital gains tax exclusion. However, it should be noted, there's a couple of downsides to be aware of. It should be noted that the person that took that exclusion now has a 2-year waiting period before they can take the exclusion again. So if that person has relocated, bought a property in some other market, and is in a line of work where they may get transferred, they cannot take that exclusion again for 2 years. So that's one thing to be aware of. But the second thing to be aware of is, right now at this particular point in the market, it's increasingly likely that the capital gains tax issue is a moot point because there's not a gain.
Unless they've lived there for a long period
Right,
of time.
right. If they've lived there a
They
long,
bought it
long time. And there's
20
also
years
record.
ago for $50,000
Right.
and it's $250,000 now.
Exactly. So it still happens, but we're increasingly seeing, it seems to me that more often the ones that say, I can't do another price reduction, let me rent it. More often, those are the people who have a relatively large mortgage, which usually means that they either bought it in the last several years or they refinanced, did a cash out refi at some point. So yeah, there are some of those examples where somebody's owned it for 20 years and obviously still is going to be making some money on it. And the other issue with respect to capital gains tax liability, although the laws have changed multiple times in the last 20 years, is it's also possible that somebody who expected they were going to, back 20 years ago, do that deferment, sell one property, roll the gain into another, back in that version of the law, has never been keeping the records to even deal with the expenses and depreciation issues so that they could minimize the capital gains tax if they had to actually go through the filing process for it. Which then means do whatever you have to so you get the exclusion so it stays off the IRS's radar screen.
But that's something you might want to check with if they've been in that property for a long time.
Yeah, and the other thing that's happening that's time sensitive along those same lines is we're now, of course we had 3 different iterations of tax credits, and remember that I think all of them had a 3-year period on them that you had to occupy the property. So if you sell or move out, it's not just if you sell, if you cease to occupy as your principal residence, on the $8,000 version, you'll owe every penny of that back, subject to certain loss limitations. But the loss is only calculated after you give back the $8,000. So in other words, the fact that you paid a brokerage fee and you sold it at a loss, let's say you sold it for exactly the same that you bought it for, and you paid a brokerage fee, so in according to that math, it looks like you lost several $1,000s. But you have to then depreciate it by the full $8,000 before a loss actually can be calculated. Then, below that point, you start to reduce dollar for dollar the payback requirement on the $8,000 tax credit. But the scenario that I had come up that I warned a client about after doing a lot of research is, had a client who was thinking of renting the property because he didn't want to sell. He just didn't want to deal with the loss he was going to have to take if he sold the property. I've had 2 of these clients where they've done this, and I warned them the problem is the day you put a tenant in, if that is so much as 1 day prior to 3 years after you closed on your purchase and occupied it, the day you put the tenants in, bang, instant $8,000 tacked onto your income tax return in the spring, instantly. So that means when you're dealing with sellers who are trying to decide, do I want to make a sacrificial decision on price, or do I want to rent because I think renting will be the easy way out to sidestep the bad market? Just remind them, if they were the recipient of a tax credit, and if that was less than 3 years ago, the second they put a tenant in the door, they owe $8,000. And then the seller does. The homeowner will.
You're certain it's 3 years?
Mm-hmm. At least under the last couple of iterations of the tax credit. So make sure as we start marketing, I just had a client that was planning way ahead. She has been in a property for 2.5 years. She and I discussed that 3-year requirement in detail at the time. I didn't remember it, but she told me that we had. And so she knew exactly what day of the year was the earliest that she could close on the property. She had me over to just look at the property here in the winter, going into the winter, just to be thinking ahead. But remember, we're now in a season where we will have tax credit recipients increasingly putting homes on the resale market. So make sure you ask questions like that and find out exactly when their closing date was, or look it up so that you know, so that you don't inadvertently either put a tenant in the door or have it close so much as a day prior to the 3 years, because the financial consequences to the client can be huge. But especially with renting. That alone, if you determine that your prospective listing client is in that spot, that alone is a huge reason to go ahead and have them make a difficult decision on pricing and focus on getting it sold. Because it defeats the purpose of renting it. If they think they're going to rent it to sidestep a bad market, they're not going to sidestep the market to the point that they're going to recover from an instant $8,000 repayment that they're going to trigger.
I think that ties in with what I mentioned at the sales meeting yesterday. They really expect us, the majority of buyers and sellers, to know what we're doing. And that means get knowledge like Matt's giving us now on that credit. I mean, that's a huge deal. And I would hate to get a letter saying you messed up and we were looking to you for $8,000 because you should have known better.
And on that subject, so Pete, you asked me, am I certain? If I were having correspondence with a client, the thing that we always need to be careful not to do, because one of the easiest ways that we get dinged is if we put on the hat of an expert for a profession that we're not licensed for. And so along those lines, we don't ever want to give tax advice as the tax authority. We don't ever want to say with certitude, I'm telling you, Mr. or Mrs. Client, take this to the bank, you won't owe that money back as long as you close after such and such a date. What you want to do, and what I've ended up doing every time it comes up, is I'm on the IRS's website, because you don't want to quote some internet site whose credibility you can't vouch for. Really, if it's an issue of the tax credit, the one sure source, if you're wanting to cite somebody, is provide a link right into an IRS resource, right on the IRS's website. Go there, that is the source. So every time that comes up, we do know more about this, and we're expecting to know more about it than our clients do. But do your research. I mean, always refer them to a tax professional, or if they have a lot line question, you can say, here's the plat, here's the shape of the lot, but if you want to know if that's critical, you got to get a surveyor, you got to get an engineer. Make sure the professional with that license is the one that's out there making that judgment call. But in the case of tax advice, number one, tell them they need to seek advice from a tax professional and that you're not one. And number two, cite your source. Say, this appears to be the answer to the question as to repayment and what triggers it on the $8,000. And then link the URL, put the URL right into the body of the email so that they are being directed to the actual source. You're not purporting to be the oracle on tax issues.
Best phrase I heard was, you need to be the source for the source, not the source. And so the idea is that you need to direct them to where they need to go to find out the information is exactly what you said.
See, I've experienced this totally with my wife. She panicked with me doing this fainting thing. So I've been through so much at Carl. They all have their specialty, from the lady that does the ID to the table to the, I mean, none of them will answer for the other person. They just send you the next person. I mean, they cover their area.
Right.
They take responsibility, but nobody, the only one was Bain that fixed my knee. He says, you got vagal vagus. You don't, I mean, he had it figured out the first day. So I've gone through all these tests, and now they said that's what you got. But not too many are just Leroy Farm boys like
Any other questions, guys? I'll hang around for a little while. Thanks for being here.
Thank you.
Thanks, Matt.